Hey, good afternoon. Today is Monday, April the 27th, 2026, and we're located in Cedar Bluff, Virginia. And the purpose of this informal fact finding today is in relationship to case docket number IFFH 1042. This hearing is convened under the Virginia Gas and Oil Act, Section 45.2-1637, which allows for objections to permit applications to be filed with those withstanding as required under Section 45.2-1632. Objections to statute have been filed against the permit for Pocahontas Gas LLC coal bed methane well G37B, application number 64222. Objections were filed by Mr. Eric Conley on behalf of Diversified Production as a royalty owner. The objections were filed in a timely manner as required by Section 45.2-1637. Notice to the parties regarding gas operation and protection of the environment are important elements of Virginia's law. Today's hearing is part of that process. Again, to you, Sarah, was notification sent to all parties to appear before this conference as required by 45.2-1637G.
Yes.
And did the notice include the date, time, and place of this conference?
Yes.
Okay. So at this point, will each party that will be testifying identify yourself?
Yes, sir. I'm Ben Street and I represent Diversified Production. I think I know that after all these months. And to my right is Scott Stevenson, co-counsel, also representing Diversified.
Any other parties?
I don't think we're going to call witnesses, but if we do, it would be
Now,
John.
at that point, we can address it and swear the witnesses in.
Mr. Stevenson, you swear and affirm that your testimony is the truth, the whole truth, and nothing but the truth?
Yes. Just to be clear, I'm not going to call him. He's a lawyer.
It's okay.
And these
Well, that's the reason I didn't ask.
including Mr. Schwartz, should
I
not
didn't
be.
ask. That's the reason I didn't ask him to swear in.
It's all right.
It's all right. It just keeps you on your toes.
Nobody else thinks I'm a lawyer either, so.
He's got that honest look about him.
Yeah.
Okay, let me continue on, then we'll get on into the hearing. Section 45.2-1637 of the Virginia Gas and Oil Act allows objections to the permit by royalty owners who are entitled to notification of the proposed operation. According to the permit, Diversified Production LLC is a royalty owner in the subject drilling unit and has standing to object to the permit application. The objections have been filed by a royalty owner against the permit application for Pocahontas Gas LLC in accordance with 45.2-1637. An objection to the permit is the criteria on which Diversified's objection is based upon the following: subsection C. The only objections to a permit or permit modification be raised by a royalty owner, or that the proposed work will directly impinge upon the royalty owner's gas and oil interests, threaten to violate the objecting royalty owner's property or statutory rights aside from his contractual rights. And again, since this is a informal hearing, if we need to take a recess, we can, and I'm going to repeat the ground rule for this hearing. Since today is an informal fact-finding conference, the purpose of this is to obtain relative facts pertaining to the issue at hand. In this case, the objectant, which is Diversified Production, will go first, and you can do testimony, you can present exhibits, documents, or any other information relative for consideration. The objectee in this case will be Pocahontas Gas, and they will have an opportunity to do so after the objectant finishes. Cross-examinations is not allowed during an IFFH. However, questions may be asked for clarification purposes. And once all parties have had a chance to present their facts and evidence. Then at the end, each party will have an opportunity to recall witness for additional testimony and or present a summary of their position in this issue. Having said that, we're ready to move forward. Mr. Street?
Okay, yes, sir. We pre-filed, possible documentation for possible uses exhibits, last week. And we identified 11 as a group, just for all of the cases today. At this point, I would just move that some of them be admitted, and I'll just list them off for you. I've got hard copies if you would like them, but you probably have a digital one. You let me know if you want the hard copy. Exhibit number 3 are 4 Oakwood orders. Those are your gas and oil board orders. So exhibit 3, 6, 7, 8, 9, and 11. 3, 6, 7, 8, 9, and 11.
I'm sorry, Ben, is 6 included?
Yes.
Okay, so
Yeah.
3, 6, 7, 8, 9, 11.
Yes, sir.
Okay,
And then, I will call, Beverly Webb since she's here. Ms. Webb is on the screen.
Ms. Webb,
Yes, yes, ma'am.
swear and affirm that your testimony is the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Afternoon, Ms. Webb. I'm gonna be quick, okay?
Okay.
Are you the primary person that was responsible for putting the well permit application together in this matter?
I'm the actual supervisor.
Okay, did someone work under you to make this happen?
Yes,
Who was that, ma'am?
that would be Stephanie Blevins.
Okay. Have you reviewed the application that Stephanie Blevins worked on under your supervisory role?
Yes.
And I have looked at this. I cannot find where anyone signed the application. Can you tell me on what page someone signed this application on behalf of Pocahontas Gas?
It doesn't look like it showed up on the print, but it is signed online on eForms.
So the copy that I would have downloaded, there'd be no way I could see see where there's a signature.
I don't think there's a signature on any of them.
Okay.
That's not the way eForms works.
Well, there could have been a signature scanned in though, right?
That's not the way eForms works. So if you look above, like on, it's page 1 of 2, there is my name representing Pocahontas Gas at the bottom of the page.
Okay.
That is how that looks on eForms.
There is on the very first, I'm sorry. Interrupted.
No, I'm done. It's on page 1 of 2, at the very bottom of the page, application certification. It says Beverly Webb representing Pocahontas Gas LLC.
Okay.
And that's how it works in eForms. There is not an actual physical signature. That's the way eForms is set up.
eForms is just like the
It's the state website.
program that is used through the Virginia Gas and Oil Board for filing that Charity does all the work on at my office. You don't know
That's
Charity?
correct.
Gotcha. Okay. Do you know what a verified signature is?
I do.
Okay. And it is a verified signature, a signature that's under oath?
Yes,
And is this application signed under oath?
yes. To the best of my information and my knowledge.
Who would have put Okay, so who signed it under oath? Was that Miss Webb? Was that you?
I
Who would have
signed
signed?
it. I signed it and then Josh Ball signs on behalf of Virginia Operations, Drilling and Completions.
Is Josh Ball's name on here as well somewhere?
It is not physically on this application, but it's on e-forms.
How does one go about submitting an E-form under oath? What's the procedure that you use for that?
I will have to defer to Phil or Brad.
Have you ever signed an application for a well permit and submitted it in a similar fashion as here and done so under oath such that you could tell me the process you went through?
Okay, so if you look on it,
Sorry, just a minute. Let me let Brad explain the E-form process. You can hear it because that's the best source is how our E-forms work.
So the E-forms is an electronic submission system that we use in Virginia for all of our permits, applications, except for any kind of submissions that gets submitted to us. We do have a section it's on what would be page 7 of our E-form application. We do have a section that's basically the application certification section, and that's the section that Ms. Webb pointed to, basically certified all persons required to be notified of the application, the proof of notices, and the application permit. That this application is submitted by our regulations, and they're able to conduct operations in Virginia. And the requirement there is they have the name of the person that's in charge of Virginia operations, and their title is put into that section.
The application on my version anyway, it has a front page. Do you have that on yours, Mr. Boyd?
No.
Just a letter. Is there a way for an applicant to basically create a letter and sign it and make it a part of the application, then upload it into your system?
We have a section in the E-forms that's called administrative attachments. We have a section on page 7, things that we don't cover under the required permitting application under that process. We have administrative documents that we need to put there. There is a section for that. If somebody needed to put something additional to what we require,
That would be possible.
Yeah.
Okay. And is there a process that your office had basically verify someone's signature for purposes of the application? Or does someone, notarize or verify pleading? Do y'all have that capacity?
we do not in this E-form application.
Okay.
this is exactly like the application that Diversified has submitted to us. It's the same signature process, just so you all will know.
Okay, but we didn't file a well application though, did we?
Diversified has, yes. With F38.
You mean on other occasions?
Yes, on other occasions, yes, I'm sorry.
Well, the reason
For an
I didn't
example,
mean
F38, we received a permit application and it is signed exactly like we do ours. Yeah,
okay, the reason I ask is because Virginia Code Section 45.2, 1631A. As I read this, it says every permit application filed with the director shall be verified by the permit applicant. And I was just wondering if you did that. Did you file a verified application? And if the answer is no, that's, tell me, but that's what it sounds like you did not do that. Is that fair? Are you,
I,
I'm sorry.
I signed it as I am required by e-forms. That's all. I
Okay,
can say.
did anyone place you under oath right before you signed it?
No,
Okay. Okay, Mr. Scruper, we filed a letter on or about February 22nd, listing our objections. We fleshed them out. I don't think you want to hear me reread them to you. So if you don't mind, I'll just incorporate those in. And then I'll proceed to the motion to stay, which we filed as well.
I prefer you briefly read them in.
Read them in.
Yes, or at least cover it in general, summarize it.
Okay. All right. Well, this is from a February 25th, 2026 letter. We submitted objections pursuant to Virginia Law, Virginia Code Section 45.2-1637C and 4 VAC 25-150-140C. We submitted 2 categories of objections and in addition, a request for a stay. The 2 categories are the proposed work directly impinges upon Diversified's gas and oil interests. Second category is the proposed work threatens to violate Diversified's property and statutory rights. The first of those categories had 2 subcategories. The first dealt with the various costs and expenses occasioned by the well. The second one is one you may want to take a second look at because you haven't heard about this before, but the underlying pooling application submitted by Pocahontas did not identify this well or any well for that matter. They did not contemplate or seek permission for the sharing of expenses. And it's our position that there should have been at least one well designated in that pooling application and order, and that the failure to do so then is not curable by coming directly to the director. It in fact usurps the board's authority. The broad second category, we incorporated the first 2, of course. The second of those is basically the same as the first one, the usurping of the gas and oil board. And then in the second category, we also, and this will be a good segue into the motion for a stay, but as you know, and as Mr. Schwartz knows, we have the unit that encompasses this proposed well was pooled back in around 1st of November of 2025. And we have appealed, of course, my client has appealed that pooling order, and it's on appeal before the Circuit Court of Buchanan County, Judge Reese Hale presiding. The well application today is entirely dependent upon the successful for Pocahontas Gas appeal, such that if that appeal goes against Pocahontas Gas, this permit application would be mooted. And as you may know, the circuit court judge has the final say on that pooling application. And I know you were there for that long set of days for the trial, but there's lots of issues, including, for example, reimbursed costs that the court is going to have to, we're going to ask the court to consider and rule upon. And Mr. Schwartz, he's positive that he and his team will prevail, and we feel confident, or more, maybe equally or more so confident that we will. But in any event, that judge is going to have to rule on that stuff one way or the other. And until the court does that, allowing Pocahontas to go onto the property and drill a well is premature because we have to wait on that court to do that. You have the authority by statute to stay whatever your decision is in this case, or stay the proceedings pending the outcome of that. This to us seems like an ideal situation for that because we have a bona fide appeal that everyone's taking very seriously. There's bukudos of lawyers and lots of clients, and they're interested, and everyone's prosecuting it. Until the circuit court judge rules on that, whatever you do today is going to be subject to that judge's order. So I don't know. I've not done this with you before. I don't know what criteria you look at for stays, or what your litmus test is. There's no precedential authority that I can find to give me guidance on what you look at for that. But to me, this is a paradigm case for that. This is a perfect case for that because we actually have an appeal with novel issues, by the way, that I think everyone, so I always hesitate to speak for Mr. Schwartz, but I know the board acknowledged in its decision in these units that there were novel issues that it had not addressed before. And so for novel issues that have never been addressed and that would merit scrutiny and a close attention by a reviewing court, that to me seems like it presents a good case, a good candidate to stay these until we know what the reviewing court should do. And I contrast that because there are certainly appeals out there that are taken willy-nilly, but this is not one of those. We have real novel issues that haven't been addressed, and that I think all parties will benefit from knowing what the answers are. And for all of those reasons, it seems to me to make better sense to put this on hold until we know what the judge is going to do on the underlying unit before we start granting permits, drilling holes, installing equipment, because that may very well prejudice some of the parties' rights on appeal, and that's not fair. So for that reason, that covers, I guess, two things at once. Part of the substantive objections is that the circuit court really has the authority at this point to rule before we jump ahead here, and also for your honor to exercise your authority under this is in the letter, of course, but it's 4 VAC 25-150 140C5, which is authority to stay pending the final decision, the statutory final decision on the de novo appeal to circuit court. And if you have any questions, I'm trying to go fast, but I'll be glad to answer them. Otherwise, that's what I had to say. That's all I have.
All right. Mr. Schwartz?
I think he's muted.
You're muted.
I have that problem. Thank you for reminding me. My first and I think overall response to what we're hearing from Diversified is the reason we have the reason why we have the Virginia Gas and Oil Act of 1990 and obviously amended from time to time thereafter was to prevent people such as Diversified or Buchanan Energy from preventing coal bed methane development by making objections along the lines of that we're hearing today. We've heard repeatedly that Buchanan Energy and Diversified are parties to or successors in interest to an oil and gas lease. They have contractual rights among themselves. We've heard all of this before. And frankly, the Virginia Gas and Oil Act was intended to prevent people from coming in and saying, we don't want this development. We want to delay it. We want to put it off. We want to prevent it. We have forced pooling so that people who object, unless they fall within the categories in the objections here to a well permit, to prevent them from deferring or delaying or absolutely preventing development. Now, turning more specifically to what we have here, the board has pooled G37. On October 21st, the board had a meeting. They announced their decision with regard to G37 and some other units. That unit has been force pooled. Pocahontas Gas is the designated operator authorized under that pooling order to produce unsealed coal bed methane gas from a panel, which was described in that pooling application. So, we have the permit applicant here actually has a pooling order in its favor from the board saying you may develop this gas in this unit, unsealed gob gas. And we're here to get a permit, actually several permits in this panel to allow that to happen. And what we're hearing in response is, well, they may have a pooling order, but we don't like that pooling order and we have an appeal. Well, they didn't prevail in front of the board. They made all the same arguments that we're hearing today about leases, about contracts, everything else, and the board decided we're going to pool this unit and we're going to designate Pocahontas Gas as operator. So the board has heard this, what you're hearing today, and they've made a decision and they appointed Pocahontas Gas as operator, and we're here pursuing development under that board order. In fact, they need to win an appeal to displace this. It's not, they're a couple of steps away from suggesting that Pocahontas Gas doesn't have the right to develop unsealed gob gas in this unit. We have an order that says we can, and we're here on a permit application to allow us to do that. The exhibits that have been offered today with regard to this application really aren't germane to whether or not the permit application is appropriate. I submit that I need to make one other observation with regard to the pooling order. Under the pooling order, everybody, royalty owners, lessees, everyone gets an opportunity to make an election. So when the board pools a unit, it says to people who have interest in the unit, you have an opportunity to decide how you want to proceed. Do you want to participate in this unit? Do you want to be a partner? Do you want to be carried? Do you want to take a pass? And Diversified has a lease from Buchanan Energy. We've heard all about that. And in this particular unit, the G unit, G37 unit, Diversified exercised their election opportunity and said, we're going to participate and we're going to be carried. So we have, people in front of you today. We have Pocahontas Gas has a pooling order. Diversified has elected to participate as a carried operator under that pooling order, which protects their lease interest. I mean, the argument here is very confusing to me. Because of Diversified's lease, they have an opportunity to become a partner that would give them precisely the same working interest they would have if they developed the property themselves. If they have a 1% interest in this unit, a coal bed methane unit, and they develop this unit, other people would have an opportunity to elect a working interest on the other 99% of that working interest. It's the reverse here. They've got a small interest here, but they do have an interest. And by electing to be carried, they have protected their leasehold interest. So they're saying that somehow the pooling order has impaired their rights, extinguished interests, whatever, when the reality is the pooling order and their election of that pooling order has actually given them an opportunity to preserve their rights and to protect their rights. So in summary, I would suggest one, this unit's been pooled. Pocahontas is the operator. They have filed a permit application to produce gob gas, unsealed gob gas, consistent with the terms of that pooling order. They have provided election opportunities to everybody. Diversified has elected to be carried. They could have elected to participate and pay up front, but they elected to be carried, but nevertheless, they're going to be a carried operator. So I would argue to you, sir, that the objections that we have somehow impacted their contractual rights, their property rights, their statutory rights, their gas and oil interests, it's simply not true. Their rights were protected by the board and are protected under the act. So those objections should not be treated as having any merit, and you should issue the permit with regard to the permit application with regard to this unit.
There are lots of appeals all the time, obviously, in our country, and some of them, the parties' positions don't change any while it's on appeal, and it doesn't create the problems that we have right here. And it'd be nice if that were the case here. We could appeal this and we would get a ruling from circuit court, and then probably we could come back and apply that ruling to the cases. The problem here is that the position of the parties will be changing if the permit is granted and Pocahontas Gas proceeds to put in a well. They're going to put in a $750,000 well. They're going to drill a hole. They're going to connect it to pipes. There's going to be assets sitting on the ground. They're going to own it. They're going to be, I guess, producing and selling gas before we get back with a ruling. And then once we get a ruling, what if my side wins at that point and said, wait, you have to repool, or you have to go through another pooling, or no, Diversified should have this unit. Now, fast forward to that position and now looking at a situation on the ground where so much has changed, it's going to be a big problem. And that's what I'm trying to avoid. Yes, we have to appeal it. I mean, trust me, I'm aware of that. I've worked on the appeal. I was there when I lost the case. I know that. But because that negative opinion followed by the appeal and a well permit and a well in place is going to change the respective position of the parties drastically. That's the reason we think it should be stayed, is to maintain the status quo on the ground. Try to unwind a whole $750,000 well that's sitting in place in Pocahontas Gas. Because you know what they're going to say when we get to the appeal. They're going to say, we've already got a well in. We've already spent $750,000. We're already pumping gas. Make them go away. And that's not the best way to proceed on an appeal, is to have the parties changing their positions so drastically. And that's what's going to happen. And I don't blame Pocahontas Gas for wanting to make that happen. If I were Mr. Schwartz, that's what I would be doing too, to get an advantage for my client. That doesn't change the fact that that's not an advantage that the board and the court should want to see. They should want the parties to be able to appeal on the merits of that decision and get an unbiased, fair ruling based on the merits and the status quo at the time of that decision, not be looking at it with all this new infrastructure on the ground, because infrastructure means a lot in these cases, as we've learned. So this is not us trying to subvert the Virginia Gas and Oil Board process. In fact, that process contemplates an appeal de novo to the trial court. And we're using the process that is in the statute. So I respectfully disagree with Mr. Schwartz on that. This is just part of the way the act is designed to function. And there's a reason why there's a statute that gives you the power to it's got to be for some circumstance, right? I mean, this seems I can't think of a better one than this to head off a situation where gas comes to court or on the appeal and says, oh, guess what, Judge? We've got, we put in 3 wells and they're $750,000 wells and we own, that's the problem. So that's why we're asking for that.
Yeah, I just want to respond just to the stay question. This well is in a location dictated by a mining company. Coronado locates these wells, these gob wells, consistent with their mine plan, with their longwall mining, to degas this coal, just like they're drilling short holes in these panels, to degas their coal in advance of longwall mining in the interest of miner safety. I mean, so in terms of the delay here, these panels are either developed, and isolated, or are in the process of being isolated. We're looking at longwall mining, we're looking at miners, we're looking at, impending mining. And there are the really awesome reason not to stay this is mine safety. I mean, these wells are located, are placed where Coronado wants them. They're degas wells. There's mining, entries are being developed. We don't need to wait for however long it's going to take the circuit court to decide this case, or however long it's going to take an appeal from the circuit court to an appellate court to decide this case. I mean, the mining is proceeding and we need to degas this coal in advance of longwall mining. And that's why we shouldn't be talking about a stay. We have a board order. We have a mining company proceeding with this longwall mining, and we need these wells.
Thank you for the freedom to talk so much, but I know you're eager to get done. We all know that that's a bit of a red herring because Coronado can vent that gas anytime they want. So that's they did that long before there was pooling and long before there was gas production. They were degasifying longwall panels. That's just a scare tactic. So that's not really an issue. And I meant to mention this earlier before. Yes, we did exercise an election on this unit, but it was very clear that election was with full preservation of all rights to object and contest and without prejudice. So that the board and the board cannot use that to our prejudice on these types of arguments. That was part of our agreement and the order that was in. So, and that's, unless he comes up with something else, I'll stop talking.
Well, thank you for answering one question, because I was getting ready to ask you the question about the election.
Yeah.
What Diversified took in this situation.
Yeah, you may not have been on the phone at that point, but we had a hearing before Judge Robertson. It's like so many of these hearings, we did a lot, and then we finally agreed that we would go ahead and exercise an election, but it was explicitly agreed and put in writing that it would not be prejudicial to any of our positions before the board. That was right before Christmas, I believe. I don't have any further. And I know I can see by Mr. Schwartz's face, he's going to give me the last word this time. So.
Well, I do have one more question for you, Mr. Street.
Okay.
In recording that, you said that your prejudice, other stuff had been recorded where?
Ask me that one more time.
As far as you say that you entered the election with prejudice, without, prejudice against it or not against it, wouldn't be held against you. Where is that officially? Who is the agreement with?
That's in an order. Who is it with?
Where?
That's an order that I believe is in the circuit court records. Is that right?
It's a stipulation on the record
Stipulation on the record.
before the judge at the hearing. I think it's also listed in our notice of election.
That's right.
Well, I just want to clarify where that's recorded, where it's been put, because I was present when that was done. Just didn't know how it was recorded or what all took place.
Yeah,
And I was asking you to clarify that for me.
We have a transcript of that hearing if you'd like to have it for the record here. If you'd like us to submit something.
Mr. Schwartz was there too. I think he probably remembers as well. It's on the record.
My argument wasn't about prejudice. My argument was about the law. The law says that to protect people, they have election rights. And all I'm saying is, under the law, people like Diversified have the right to preserve their working interest. The law protects people like you. I'm not saying you waived anything. I'm just saying the design of the law is to protect people in your position, to protect lessees, to protect royalty owners. That's all I'm saying. It
No,
was designed to anticipate this.
We were trying to satisfy Mr. Scaripa's questions about whether or not there was a specific reservation of rights under that agreement. That's what we were trying to answer.
Well, but I'll still have one follow-up of my own. You made an election and, with the other part, there's a lot to be said one way or the other for it, but you did definitely choose to make an election on this unit, correct?
We did, yes.
Okay, that's all. That's a straight answer. Okay.
It is
The question.
conditional on the appeal.
Well, I understand,
Yeah.
but you did make an election.
No, we did, because the time limit was
I
running
mean,
and
it's a fact. This is what I meant. It's a fact. You made an election. Other stuff is not necessarily a fact.
by other stuff, do you mean, did we reserve our rights? So,
I mean, but you still made an election. That's a
Yes, but-
whole little,
but to understand what election we made, I think you have to understand the circumstances.
that was Diversified's cause, what election you made. I mean, however you made it, whatever circumstances, you still made that election. That's all I'm asking. Straight yes answer, no.
That is not a question that can be answered in a yes, no, but I'll tell you what we did, and I hope this will answer completely. We filed a motion first with the Virginia Gas and Oil Board to delay and suspend the election time period. And because we filed it like 6 days in advance, I think the board ended up, and you agreed that it was filed too late, so the board didn't consider it, so we had to appeal it. So we went to Judge Reese Hale, and I think we filed a different motion. We may have briefed it. I don't remember. We had a full hearing. And in the middle of that hearing, and Pocahontas Gas was there, we were there, the judge was there. I forgot who suggested it, but by the end of it, we agreed that we would go ahead and have the right to file an election, but with the very important understanding and agreement, which was the key to the whole thing, which was we would not be prejudicing any of our rights to object or contest in any other matters. And it took us a while to get there, but the judge was happy with that, and that's what we did. So yes, and then we filed a written election. And within that election document, I think he's saying this, and I think he's right. We included specific language that pursuant to the court order, we were not waiving or releasing any of our rights to object or to be prejudiced on any related matter. So yes, we did file an election, and I think it was carried. But I do think you have to understand the caveats and what went on with that election to get the whole picture. But
I was present in that meeting with the judge.
okay, all right. I'd forgotten that. I'm sorry. Does what I said fit with your
You've
record?
answered my question.
Okay, good. All right.
I'm not going to take the lid off the jar, sir.
Me either. I don't know what he said.
Comments, Mr. Schwartz, no further comments?
No further comments. I think we've finished.
Good. Having both parties have had their opportunity to present their facts, I will take all the facts in consideration and will issue a written decision within the time frame.
Okay, before everybody disappears, Ben, can we just say that we would have the same hearing on the next matter? Do we need to start over with that, or is there anything different?
I think I'm okay with that. Let me ask my
But
co.
let's close this one
Okay.
and we can do it. But my suggestion, if that's what you want to do, we can close this one, briefly just open it, and that's the agreement not stipulated, we can.
Okay, let them have a moment though, because I think they
Yes.
want to talk. Yeah.
So this one's officially adjourned.
Okay, so then we'll log in again.